we have the Senate President Pro Tem, Patty Murray, here, and I know of your busy schedule and important things you have to do today. So let me say at the outset, we'll hear from 5 judicial nominees: Kevin Ritz, U.S. Court of Appeals for the 6th Circuit; Brian Murphy, U.S. District Court for the District of Massachusetts; Judge Rebecca Pennell, U.S. District Court for the Eastern District of Washington; and Jeanette Vargas, U.S. District for the Southern District of New York. Congratulations to all the nominees, families, and friends. I'll be introducing Mr. Ritz, but Senator Murray, I know you're here for a specific introduction, and I turn the floor over to you.
Mr. Chairman, thank you so much for the accommodation. I am really delighted to be here today with the committee to introduce an incredibly qualified judicial nominee from Washington State. I was proud to recommend Judge Rebecca Pennell to serve as the U.S. District Court Judge in Eastern District of Washington. She is here today with her husband and her daughter, her dad, her sister, and her brother. Thank you all for being with her today to support her. Like the other 9 federal judges we have confirmed at my recommendation, Judge Pennell has been vetted and endorsed by my state's nonpartisan Judicial Merit Selection Committee, which is made up of Democratic and Republican legal experts. After reviewing her record and the many letters of recommendation that came with her nomination, it is easy to see why. In letter after letter, prosecutors, law enforcement officials, judges, and so many others described Judge Pennell as fair, insightful, professional, and prepared. Judge Pennell's long and impressive history in Washington State's legal community has clearly earned her the respect of her colleagues and a reputation for being a fair and thoughtful judge. And Judge Pennell's Washington State roots run as deep as her impressive legal knowledge. She grew up in Richland, where her father worked at the Hanford Nuclear Reservation. She attended the University of Washington, returned from Stanford Law to clerk for District Court Judge Whaley in Spokane, and she's been an active and respected member of our state's legal community ever since. From her work providing wraparound legal services for vulnerable children, to her leadership establishing drug court reentry programs in Yakima and the Tri-Cities, to her 15 years in the Federal Public Defender's Office and 8 years on the Washington Court of Appeals in Spokane. Judge Pennell has shown herself to be a true public servant, committed to ensuring people in Washington State can access a justice system that treats people fairly and works for everyone. And in addition to being highly respected in her community, Judge Pennell is someone who cares about her community and is active in it, as shown by her participation in the Yakima Downtown Rotary Club, the Washington State Civil Legal Aid Oversight Committee, and her past service on the boards of the YWCA of Yakima and the Yakima Area Arboretum. It's important that we have a court system that delivers justice for everyone, not just the powerful and well-connected. That requires a judge who carefully reviews each case on its merits, shows a deep understanding of the law and respect for everyone who appears before them, and appreciates how their decisions will affect the lives of people across Washington State. I have no doubt that Judge Pennell fits the bill to a T, and I'm confident the committee will see that as well today. Thank you very much for your consideration. I look forward to working with you as we move this nomination through.
Thank you very much, Senator Murray. Thank you for coming before this committee. We know you're busy and have to go on to your own schedule from here, but you're always welcome, and thank you very much for your presentation. At this point, I recognize Senator Graham for an opening statement.
Thank you, Mr. Chairman. I want to talk about what I brought up here yesterday. After weeks of effort, we finally found out the situation with Mr. Ibarra, who's facing charges for murder in Georgia. So this man is a case study of what's wrong with our immigration system. And in terms of legislation, you don't need any legislation to fix the problem related to Mr. Ibarra. He was apprehended in September 2022. He lived in Venezuela, then he went to Ecuador illegally, resided there. He came across the U.S. border. We got a hold of him. We apprehended him, and he was paroled. And why was he paroled? Lack of detention capacity. The law is clear. You cannot parole someone because you don't have space. The only way you're allowed to be paroled in the United States is to meet two criteria of a statute. Where's the stuff about, do you have my testimony with examination of Mayorkas? I brought this up in November. Mayorkas was appearing for the Appropriations Committee. And he said yesterday he didn't know why Mr. Bear was paroled. It's in your own file. How could you testify before the country? You didn't know how the guy got into the country when at the literally almost the same moment, I'm giving you a document that said he was admitted into the country because lack of capacity in El Paso. So the bottom line here is when I asked him in February about whether or not you're letting people into the country violating the statute, he says, do you do a case-by-case analysis? Senator, we comply with the law. So there's a file for all 240,000 where somebody determined they must meet these two criteria, urgent humanitarian need or significant public benefit. There's an individual determination made, Mayorkas, on all 220,000, and I can see that. Yes, sir. There was no individual analysis done by the man charged with killing Laken Riley. Nobody determined whether or not he has a unique benefit to our country or that he's suffering from a humanitarian crisis in his family or with some loved one, allowing him to be paroled. He was paroled because we didn't have any place to put him. And he wound up committing a crime in New York, and now he's charged with murder. If this is not Exhibit A of a broken immigration system, what would be? And the day that I give this committee why he was paroled from his own file, the same day the Homeland Security Secretary testifies that he doesn't know why he was paroled. We're going to have an impeachment trial of Mayorkas, in theory, but not in practice. We're not going to get any of this information. I would like to be able to tell the public that when he talked to me in November, Mr. Mayorkas, about the system, that what he said's not true. He was saying there was an individual analysis consistent with the law. The law does not allow parole because you don't have a place to put somebody. We're not going to have that trial because you don't want to hear about why he was impeached. You don't want to have a discussion as to whether or not he has broken his duty to protect America. So all I can say, this is not going away. The trial may go away. You may deep six this thing in about 3 hours, but the issue's not going to go away. We're going to tell the American people until we run out of breath that the system in place is broken. It leads to results like in Georgia, and it needs to stop. And the person who created the problem is Joe Biden. He's the person who needs to fix it. And finally, as to parole, this system is supposed to be an individual case-by-case analysis. During the Trump-Biden years of their presidency, on average, 5,400 people were paroled in the United States, meeting those two criteria. Last year alone, it was almost 800,000 paroled by the Biden administration. Blanket parole, no individual analysis. So when Mayorkas testified in November, what he said is not true. And this is Exhibit A. Thank you.
Senator Graham, you've raised an important issue and it's one that's always timely, but I think there's another perspective that ought to be shared. First, let's talk about Senate math. In Senate math, you need 60 votes to pass anything of significance. That means it has to be a bipartisan effort. You need not only one party, but some participation from the other side and the other party. I've been engaged in this debate on immigration for over 2 decades, and I know the reality. The reality of the situation is the only thing that makes progress is a bipartisan effort. I was part of the Gang of Eight, as was Senator Graham, which tried more than 10 years ago to pass comprehensive immigration reform and succeeded in the United States Senate. The measure was not taken up in the House of Representatives under Republican leadership. This time around, we all acknowledge that there are serious problems at our border that need to be addressed. It's a myriad of elements that have led to a refugee crisis, which has hit the United States as well as many other countries. There was a suggestion that we sit down and write up a bipartisan bill, see if we could find some border reform and change to avoid some of the tragedies that have been described. And the insistence on the Republican side was that their leadership in putting together that bipartisan bill would be James Lankford, a conservative Republican senator from Oklahoma, a well-respected senator, I might add. On our side, Kirsten Sinema, independent, as well as Chris Murphy from the state of Connecticut, were participating in the same effort. For weeks and months, they worked together to come up with a bill to address many of the issues that have been raised by Senator Graham, particularly the lack of detention facilities to deal with the onslaught of people who are presenting themselves at our border, what to do with them, and what to hold them, how to hold them in a humane fashion for a period of time to keep us all safe. It was an extraordinary effort on their part, and they succeeded to write such a bill. It was a bill which I didn't agree with in all its detail, but I can tell you, having been engaged in this issue for many decades, you don't get what you want in its entirety. You have to be ready to compromise. And so we brought this bill to the floor, the Lankford bill, Murphy bill, Sinema bill, bipartisan bill, just a few weeks ago in an effort to try to do something on a bipartisan basis and to get something done at the border. Part of the effort was the president, who engaged in it as well and bought into the legislation and said he would support it. It included a massive investment in detention facilities so that we could hold people who might be suspect or dangerous. And that was one of the key elements in that bill. What happened to that bill when it came to the floor? 4 Republicans voted for it, only 4 out of 49, and it didn't get enough votes to move forward. What happened? This was a bill that was agreed to on a bipartisan basis. Senator Lankford helped to craft the bill. It had elements that Democrats liked and disliked, the same thing true on the Republican side. What changed? What was the thing that changed? One thing changed. The Republican candidate for President, Donald Trump, announced that he wanted all of his loyalists to kill that bill, and they did. Donald Trump then announced publicly, he said, you want to blame me for this? Go ahead and blame me. I am blaming him. His hands are unfortunately soiled by this process. So this notion that we are not addressing this in a realistic fashion in a timely way is not true. I can just tell you the bottom line was the decision was made by Donald Trump that he'd rather have the issue than a solution that might reflect on both parties in a positive way, including the president. I think that was a serious mistake. When we get to the point of changing our border policy, it will be on a bipartisan basis. And I hope we can come up with a measure as constructive and positive as the one that Senator Lankford and the others came up with. Senator Warren is here to make an introduction. Senator, I recognize you at this point.
Thank you, Chairman Durbin. I appreciate the opportunity to come before you to introduce Brian Murphy, a nominee to the District Court of Massachusetts. Senator Markey and I were proud to recommend Mr. Murphy to President Biden for his appointment to the federal bench. Mr. Murphy started out as a public defender in Worcester, Massachusetts, and since then he has dedicated his career to representing individuals in state and federal criminal court. Initially, he was a solo practitioner in Worcester. Mr. Murphy is now the managing partner of a law firm of 12 attorneys. Mr. Murphy's professional life has been defined by his dedication to the Constitution. His initial focus was on criminal defense at the trial and appellate level. Though his practice has broadened, he remains deeply committed to ensuring that every defendant has the right to a lawyer, regardless of income or status. He has shown this commitment through his criminal defense work in state and federal courts and has also managed civil and probate matters. His experience in court is impressive. He has tried more than 40 cases to verdict as sole counsel or chief counsel, more than half of which were jury trials. In addition, as managing partner, he is responsible for supervising and supporting attorneys at his firm as they develop their lawyering skills, as well as leading strategic business decisions. Mr. Murphy is a staunch and committed advocate. He sees the humanity of the individuals he works with and he strives to make sure that the interests of justice are served. He serves and supports his community inside and outside the courtroom. He is fair and well respected by prosecutors, defense attorneys, and other members of the Massachusetts legal community. They all speak of his outstanding preparation, his even temperament, and his professionalism. I am proud to express my support for his nomination to serve as a federal judge on the district court in Massachusetts, and I am happy to see that he is joined here today by his family and friends, including his wife, Lindsay, their 3 children, his parents, Margaret and Ed Murphy, his sister and niece, and his brother and sister-in-law. We have a large contingent here today, and I'm delighted to welcome them all. I want to congratulate Mr. Murphy on this achievement, and I want to thank the committee again for the opportunity to introduce such an outstanding candidate this morning. Thank you, Mr. Chairman.
Thank you, Senator Warren. Senator Gillibrand.
Thank you, Mr. Chairman. Thank you, Ranking Member Graham and the members of the Judiciary Committee. I'm delighted to be here to introduce Jeanette Vargas, a brilliant lawyer and dedicated public servant. I was proud to recommend Ms. Vargas to President Biden to serve as a district judge for the Southern District of New York. Jeanette is an extraordinary lawyer with impeccable credentials who has dedicated her career to public service. She's here today supported by her family, friends, and former colleagues. In so many ways, Jeanette's story represents the very best of our nation. Her parents were raised in low-income households and instilled in her the values of hard work, education, and the necessity of giving back. Her father came to New York from Puerto Rico as a child and was largely raised in the foster care system. He then attended community college and transferred to NYU to complete an engineering degree while working various jobs, including as a taxi driver. Her mother, the daughter of 2 immigrants, raised 2 children while attending community college at night, eventually graduating with a degree in social work. Jeanette graduated from Harvard College and Yale Law School and then went on to clerk for then's Judge Sotomayor, who recommended Jeanette for this judgeship in glowing terms. For more than 2 decades, Jeanette has used her education and her talent to serve a single client, the United States of America. She served as Assistant United States Attorney for the Southern District of New York, steadily rising through the ranks, serving under 4 presidents, 2 Republican and 2 Democrats. As Assistant U.S. Attorney, Ms. Vargas has defended diverse matters on behalf of the United States and its various agencies, departments, and officers. She's tackled constitutional questions, matters of national security, and civil rights prosecutions. And she's handled False Claims Act investigations, complicated tax disputes, and intricate bankruptcy cases. Over her impressive career, Ms. Vargas has tried multiple cases to verdict. She has taken or defended over 100 depositions, argued and briefed dozens of motions in district court, argued 10 cases before the U.S. Court of Appeals, and helped draft more than 24 appellate briefs. She has some of the most extensive federal legal experience of any nominee before this committee. Throughout her work, Ms. Vargas has always shown extraordinary integrity and judgment. It's why 59 former colleagues from across the political spectrum submitted a letter of support for her confirmation. In it, they noted that she has led high-profile cases, including politically sensitive matters, without an ounce of political bias. She has served without fear or favor, dedicated to doing the right thing in the right way for the right reasons. Despite her incredible experience and impressive credentials, I found her to be humble and unpretentious. She listens carefully and exudes an air of thoughtfulness and attention. Her former colleagues say she's an excellent judge of character and credibility, inspiring profound respect among her peers. I know her humility, integrity, and tenacious work ethic would make her an excellent judge, and I urge the committee to confirm her to the Southern District of New York as swiftly as possible. I want to thank Ms. Vargas' family and friends for joining us today, and I want to thank everyone on this committee and the opportunity to be heard before the committee. Thank you.
Thank you, Senator Gillibrand. Senator Markey.
Okay. Thank you, Chairman Durbin. And I come before the committee today, like Senator Warren, in strong support for the confirmation of Brian Murphy to the United States Court for the District of Massachusetts. Mr. Murphy is a highly respected and valued attorney in Massachusetts legal circles. And the many legal practitioners in the Commonwealth with whom I've spoken about his experience are excited to see this nomination. Mr. Murphy started his career as a public defender in Worcester, There, he gained valuable insight into and knowledge of the issues litigants face every day in courtrooms where their lives and liberties are at stake. Throughout his career, Mr. Murphy never gave up on his belief that those accused of crimes have a right to strong, committed representation. After serving as a public defender, Mr. Murphy continued to practice criminal defense at Todd & Weld and later started his own firm of Murphy & Rudolph, where he continued in his work to protect and uphold the fundamental constitutional rights of all Americans. Mr. Murphy has an impressive academic background as a graduate of Columbia Law School and Worcester's own College of the Holy Cross. In law school, he showed an early passion for justice, serving as the editor-in-chief for the Columbia Human Rights Law Review. Most importantly, Mr. Murphy has lived and worked in Massachusetts his entire legal career. And as a Boston College double eagle, I even forgive him his Holy Cross undergraduate degree, as he's dedicated his legal career to serving the people of central Massachusetts. He understands the community where he will hear cases and make thoughtful, balanced decisions that affect the citizens of Massachusetts. He has a strong knowledge of our people, including those in the most disadvantaged communities, and our culture to complement his strong knowledge of the law. Based on the strong support Mr. Murphy has from the legal community in Massachusetts, I have no doubt that he will be an excellent addition to the federal bench because of his background of representing people accused of crimes. I know Mr. Murphy will keep the principles of fair play and substantial justice central to his courtroom proceedings and decisions. So I thank the committee for having me here today, and along with Senator Warren, we urge you move Mr. Murphy's nomination forward so the Senate may swiftly confirm him. Thank you, Mr.
Senator
Chairman.
Markey, Senator Warren, and Senator Gillibrand, the three of you for coming to attest to
Thank you so much.
qualities of these nominees. I know you have a busy schedule, so we appreciate your being here. I'm pleased to introduce Kevin Ritz, nominated to the U.S. Court of Appeals for the Sixth Circuit. Mr. Ritz grew up in Memphis, and he received his BA from the University of Virginia. He went on to earn his MS from the highly respected Georgetown University School of Foreign Service and his JD from the University of Virginia School of Law. After law school, Mr. Ritz served as a law clerk to Judge Julia Smith Gibbons on the U.S. Court of Appeals for the Sixth Circuit in Memphis. He then began working as an assistant U.S. attorney in the U.S. Attorney's Office for the Western District of Tennessee, went on to serve in a variety of roles within the office, and as appellate chief, he personally wrote more than 200 briefs and argued 37 federal appeals. After receiving blue slips from both Tennessee senators, Mr. Ritz was confirmed by the Senate to be U.S. Attorney for the Western District of Tennessee by a voice vote in September of 2022. In that role, he serves as the Chief Federal Law Enforcement Officer for the 22 counties of the district and supervises the other attorneys in the office. As U.S. Attorney, Mr. Ritz created the National Security and Civil Rights Unit within the criminal division of his office. He also regularly meets with and convenes law enforcement and community partners to discuss violent crime reduction efforts and other priorities. I congratulate Mr. Ritz and his family on his nomination and look forward to hearing his testimony today. Senator Blackburn is asked to make remarks, and I now recognize her for 3 minutes. Senator Blackburn.
Thank you, Mr. Chairman. Let me begin by saying just how disappointed I am that the Biden administration has once again shown little regard for the long-standing bipartisan tradition of consulting home state senators on judicial nominees. Senator Hagerty and I attempted to work in good faith with the administration. We identified highly qualified nominees to fill this vacancy, but unfortunately, the White House had other plans. It is abundantly clear that despite the White House assurances to the contrary, there was a backroom deal to appoint Mr. Ritz to this vacancy from the very start. But the most glaring example of the White House outright refusal to consult is the fact that they have not even bothered to ask what our objections to Mr. Ritz might be. Had they done so, I would have explained my serious concerns about his professional ethics, concerns that should alarm those in the White House pushing his nomination, and concerns that we have heard from many of his peers. In our country, every individual accused of a crime is entitled to due process under the law. That is a bedrock principle of justice. But that's not how Mr. Ritz has operated as a prosecutor. Mr. Ritz has been accused of using highly unethical bait-and-switch tactics to trick indigent criminal defendants into accepting plea deals they didn't agree to. And when defense attorneys pushed back, Mr. Ritz has been accused of making outright false statements to the court to cover up his misdeeds. Indeed, Mr. Ritz has chosen to surround himself with those who seemingly treat their ethical obligations with disdain. Mr. Ritz's deputy, for example, received a 1-year probation for prosecutorial misconduct. We have heard from many of his peers and colleagues. You don't have to take my word for it. Just ask Stephen Shankman, the former federal public defender for the Western District of Tennessee. Mr. Ritz has such a reputation for unethical behavior that when Mr. Shankman first heard reports of a prosecutor behaving unethically, he knew it had to be Kevin Ritz. Writing about Mr. Ritz, Mr. Shankman said, and I quote, "This is not the first, second, third, or whatever occasion that this sort of thing has occurred, but everyone should be aware of this unfortunate pattern of behavior. You should be aware, your clients should be aware, and you should proceed with extreme caution," end quote. You should proceed with extreme caution. What an admonition. Is that how the American citizen should be made to feel if they were to go into a courtroom with the presiding judge being Kevin Ritz? With an ethical record like this, I question how the ABA could give him any rating other than not qualified. He has no business representing the United States in a courtroom, let alone presiding as a judge with a lifetime appointment. But Mr. Ritz's record of unethical behavior isn't my only objection. Under his watch, as the chief federal law enforcement officer, the city of Memphis has become the most dangerous place to live in the United States. That is a fact. In 2023, Memphis had the most homicides in its history, and data shows that 2024 homicides are going to outpace 2023. Law and order has completely collapsed in Memphis under his leadership, and there is no more tragic example than last week's murder of a Memphis police officer. Officer Joseph McKinney was shot and killed on Friday by a criminal who had been arrested just weeks prior for 4 felonies, including unlawful possession of a weapon and possession of an illegal Glock switch. Make no mistake, the criminal would not have been out on the streets but for Mr. Ritz falling asleep at the wheel. His inaction has cost lives. Prior to Mr. Ritz's tenure, the U.S. Attorney's Office had a policy of charging 100% of prosecutable gun crimes. Why Mr. Ritz did not follow through on this, I do not understand. But we do know a police officer, a father, and a Memphian, they are dead because of Mr. Ritz's lack of leadership.
Senator, your time
Thank
has
you,
expired.
Mr. Chairman.
Let me say at the outset that Mr. Ritz will be before this committee for questions from all senators and have an opportunity to respond. Senator Blackburn asked for this special privilege of speaking out of turn, and I gave it to her and extended her time an additional 2 or 3 minutes in an effort to accommodate her in a fair fashion. Let me say at the outset, Mr. Ritz has been judged by the American Bar Association. To judge him and his prospective nomination, they contacted attorneys in the area as well as judges. Their conclusion, unanimously well qualified. Unanimously well qualified. If that sounds different than what you just heard, it is. Second, I want to address this notion that we have some kind of backroom deal here. The senator has been selective in talking about the facts that led to this nomination. Let me tell you the history. It takes a minute or two, but it's worth it. As many of you may know in this room, blue slips are literally blue slips of paper issued by this committee as a courtesy in order to seek input from colleagues on nominees from their home states. During the Obama administration, Senator Leahy chaired the committee and honored blue slips for both circuit and district court nominations. If a senator did not return a blue slip for a nomination from his state or her state, that individual nominee did not move forward. That was the tradition under Senator Leahy. As a result, Senate Republicans held multiple circuit seats open during the Obama administration that President Trump later filled. Both parties do that. But when Senate Democrats expressed reservations with President Trump's picks for circuit seats in their states, Senate Republicans reversed their thinking. They did away, the Republicans, when they were in charge, did away with blue slips for circuit court vacancies and held hearings on 18 circuit court nominees who did not receive blue slips from their home state senators. I objected at the time, as did many of my colleagues, but we also repeatedly warned the Republicans were establishing new ground rules when it came to blue slips for circuit court judges. I've said it many times, there cannot be one set of rules for Republican nominees and another for Democratic nominees. So today and throughout this session, I am following the same standard the Senate Republicans set. Senate Republicans confirmed a nominee to the Third Circuit after the Trump White House refused to let Democratic home state senators even meet with him. Another Third Circuit nominee was informed that he would be nominated weeks before the Trump White House had a single conversation about the vacancy with Senator Casey of Pennsylvania. And the Trump White House counsel informed Senator Baldwin of Wisconsin during their very first conversation about a Seventh Circuit vacancy at the White House that they'd already selected a nominee without her knowledge. That doesn't seem like much consultation to me, but Senate Republicans said it was plenty. Given that history, the White House consulted with the Tennessee senators on this very vacancy, significantly more than precedent requires. The White House has been discussing this Senate seat with the Tennessee senators since August of 2023. They exchanged names of potential candidates in October of 2023. Mr. Ritz interviewed with members of the Tennessee senators' staffs in both October and November 2023. The White House counsel's office interviewed the Tennessee senators' suggested candidates in November of 2023. The White House then gave the Tennessee senators the opportunity to choose from 3 candidates, including Mr. Ritz. The Tennessee senators refused to do so. The White House also repeatedly offered the Tennessee senators the opportunity to interview Mr. Ritz. Senator Blackburn did not take them up on the offer until March of this year, and Senator Haggerty did not conduct an interview of Mr. Ritz until yesterday. My Democratic colleagues would have been grateful to receive such courtesy from the Trump White House. But what did Senator Blackburn offer instead? Calling this a backroom deal. Senators Blackburn and Haggerty may have preferred another individual for the vacancy, but consistent with precedents set by former Republican chairs of the committee, we will proceed with the hearing for Mr. Ritz. It's now time to call
Mr. Chairman, there are inaccuracies in your statement. I'll be happy to submit a timeline and the fact that on Christmas Eve we received an email that they were going to nominate Mr. Ritz, but I'll submit those in writing for you.
Thank you very much, Senator. First panel is Mr. Ritz, and will you please approach the table as they change the nameplates. If you'll please stand and raise your right hand, do you affirm the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that the nominee is answered in the affirmative. Mr. Ritz, you have an opportunity now for an opening statement, and then members of the committee will have a chance to ask questions. Please proceed.
Good morning. Thank you to Chair Durbin and Ranking Member Graham for holding this hearing. Thank you to the President for nominating me. and thank you to Senators Blackburn and Hagerty. I come before this committee as a lifelong public servant. Public service defines me. I've spent my entire adult life serving our country. To continue that service as a judge on the Sixth Circuit would be such an immense privilege. I grew up as a public school kid in Memphis. 20 years ago, after graduating from law school, I moved home to Tennessee to clerk for Judge Julia Gibbons on the Sixth Circuit. Judge Gibbons is a legend in the federal judiciary, and she was also the best boss and mentor a new lawyer could ask for. My clerkship with Judge Gibbons ended on a Friday in August 2005. The following Monday, I moved one floor down in the federal building to start work as an assistant United States attorney. 19 years later, I'm still there. As an AUSA and now as United States Attorney, I've spent my entire legal career keeping people safe in West Tennessee. I'm proud to say the United States is the only client I've ever had. For 12 of those years as appellate chief, I had the privilege of practicing every day in front of the Sixth Circuit. I wrote hundreds of briefs and argued in front of the court 36 times. The judges of the Sixth Circuit were always fair, prepared, and gracious. The possibility of serving with these distinguished jurists on a court for which I have such deep respect is humbling. I want to thank my colleagues, past and present, at the U.S. Attorney's Office. It was such an honor to be unanimously confirmed as United States Attorney. I'm proud of my team and our law enforcement partners for the work that they do to uphold the rule of law in West Tennessee. Before I recognize members of my family, let me say I'm honored by the presence of friends who have traveled from Tennessee to be here, as well as by the many colleagues, friends, and family members who are watching back home in Tennessee and elsewhere. I'd like to introduce my sister, Michelle, and her family who traveled from Atlanta. My parents, Mike and Sharon, traveled from Memphis to be here. Dad had a distinguished career of public service in city and county government, and my mom was a public school teacher in Memphis. Mom and Dad taught me the importance of patriotism and public service. And as a lifetime public servant and career prosecutor, I can only hope that I've lived up to the lessons they taught me. Finally, I want to thank my wife, Anna, my best friend and partner. I'm in awe of the work that Anna and her colleagues do at the Fundraising and Awareness Organization for St. Jude Children's Research Hospital in Memphis. In true Tennessee fashion, Anna and I met at a barbecue contest, and I'm so glad that we did. Thank you, Anna, for being at my side every day. Again, thank you for holding this hearing, and I look forward to your questions.
Thank you, Mr. Ritz. At the outset, let me say, as I did before, that you have been found unanimously well qualified by the American Bar Association after they have asked members of the bar and elected officials as well about your performance throughout the course of your life, and particularly as U.S. Attorney. With unanimous consent, I'm going to enter into a record letter which we received from the Federal Law Enforcement Officers Association, in which they say of your nomination, at every turn throughout his nearly 20 years serving the Western District of Tennessee, community leaders and law enforcement leaders who know Mr. Ritz have come away deeply impressed at how thorough and principled Mr. Ritz has shown himself to be time and again. You've heard some of the charges that have been made by Senator Blackburn. Would you like to respond?
Yes, Senator. A couple of things. First, I want to say, before I say anything else, how deeply saddened I was to hear about the death of Officer Joseph McKinney Friday morning in Memphis. That happened 15 minutes from where I live, and it has saddened our community immensely. I reached out to Chief Davis and the mayor on Friday to say that they had my condolences and support. Officer McKinney, I mourn for his family because he kept my family safe. That's why there's no higher priority for us than tackling gun violence and violent crime in Memphis. There was a reference to a third-hand communication allegation that was made, I think it was 16 years ago. That was an allegation that was looked at by a court, and there was no finding of any unethical conduct. I have had a career senator of clean, ethical record and would issue an open invitation to anyone to speak with judges, opposing counsel, and anyone that I've worked with in West Tennessee.
Could you comment in general terms about the fact that in public service there are usually critics, some of us even find them for senators. What has been your approach to that in the past?
Senator, I appreciate the question. You know, until 19 months ago when I became United States attorney, I was a worker bee. I was an assistant U.S. attorney and did not face the public as I do now as United States attorney. I can assure all of you who do face the public, it's been a learning curve for a former appellate lawyer to learn how to address tough questions. We don't shy away from them in the U.S. Attorney's Office in my current role. I'm proud of the work that we've done, and I've made an intentional effort to make myself and my team available to community members, to the press, and to partners all throughout the 22 counties of our district. And as I say, I'm proud of the work that we're doing.
Mr. Ritz, I see from 2011 to 2014 you represented the government in United States versus Castleman.
That's right.
That case involved the question of whether someone convicted of a crime of domestic violence could possess a firearm under federal law. Eventually, the case made it all the way to the Supreme Court, and a unanimous court sided with you and the government. Can you tell us about your role in that litigation?
Certainly, Senator. As you say, that was a case that came out of West Tennessee, and I got involved when it was at the Sixth Circuit level. Really important case about the federal law that prohibits people from possessing firearms if they have a prior domestic violence conviction. So it's of course a very important tool and has been an important tool for federal prosecutors in our district and elsewhere to keep firearms out of the hands of domestic abusers. I got involved in the Sixth Circuit litigation, wrote a brief and en banc pleadings at the Sixth Circuit. It did end up going to the Supreme Court, and I worked very closely with the Solicitor General's office and was invited, because I had worked so closely with them, to sit at counsel table at the Supreme Court argument. I think it was 2014.
Was that the only case you've had involved in before the Supreme Court?
It was, and I want to be clear, I was not the person, arguing the case, but I was at counsel table that day.
Thank you. Now recognize senators for 5 minutes of questioning. The first senator is Senator Blackburn.
Thank you, Mr. Chairman. Mr. Ritz, I will tell you, I have been so disappointed as things have come through. Senator Hagerty and I gave you the benefit of the doubt for the U.S. Attorney, but we have heard from so many people in West Tennessee of their frustration with you. So when you look at this, how can criminal defendants that come before you as a judge think you're going to give them a fair shake? How can attorneys that expect their clients to be treated fairly in the courtroom expect that you're going to behave ethically and not discredit them, not discredit the attorneys?
Senator, in my career, 19 years, the only job I've had as a lawyer is to represent the interests of the United States and keep people safe in our state.
How about the people of Tennessee?
And we represent the people.
Because that should be a priority too. You referenced the previous allegation against you. The court never addressed that because the attorney withdrew from the case. Okay, let me ask you this. You hired a number 2, Reagan Taylor Fondren, who received a year of probation for prosecutorial misconduct, including unconstitutionally burying evidence and misleading the court. Why did you hire her, and what was the follow-on with that?
Senator, our first assistant United States attorney, I did not hire Ms. Fondren. She has been a dedicated public servant her whole career. I promoted her to be first assistant. As with all of my AUSAs, I am proud of the work that they do to uphold the rule of law and protect people.
Let's talk about the people of West Tennessee, because your primary duty as a U.S. attorney is to keep the people of West Tennessee safe. Memphis is more dangerous under your leadership, and it's a direct result of your lax policies of not prosecuting violent crime. We know about the Lobley case, and we know that he had been charged with 4 felonies, including unlawful possession. So the Shelby County DA has publicly stated that the Lobley case was accepted for federal prosecution. Is that accurate?
Senator,
yes or no?
9 days before the tragic killing of Officer
Yes or no?
McKinney, our office did accept that for potential federal prosecution. We were
Okay.
diligently investigating that case.
Let's talk about this. The prior U.S. attorney brought 100% of prosecutable gun cases. If you weren't in charge, Mr. Lobley would have been behind bars.
I want to say, Senator, if I may, I have no control over the state system. Mr. Lobley had been arrested in the state system and released on bond in the
Federal
state.
charges.
He was arrested.
Federal charges. You and the DA have a difference of opinion on this.
No.
Because he says he was accepted for federal prosecution.
And referenced
So-
for our consideration, but we had not yet charged Mr. Lobley, Senator.
Okay, so you were not moving at the pace of your predecessor. Let me move on to sex offenders. Because in May of last year, you stated, and I quote, "Most convicted sex offenders who live and work in West Tennessee are productive members of the community." What would you say to the families whose children's lives have been ruined by sexual exploitation and abuse? And how do you think that they feel knowing that the chief law enforcement officer, their chief federal law enforcement officer, believes that these sex abusers are productive members of the community?
Senator, I don't believe I said that.
I'll
there may
provide
be,
you with the quote.
I'd be happy to respond in writing,
Yes.
but I can tell you, Senator, we have an
You
active...
made that quote. Let me move on because if you'll respond in writing, I wanted to raise the issue we talked about previously, which is you removed the Tennessee flag from the U.S. Attorney's office after you were sworn in. And we have heard from several people that you did this. So I want to know, you told me it was because you thought the office was cluttered that you removed the flag. But you were there for the people of West Tennessee. You removed the Tennessee flag. So what did you do with it? Did you throw it in the trash? Did you put it in the closet? Why did you not see your appointment as having a duty to the people of West Tennessee?
As Chief Federal Law Enforcement Officer, Senator, I represent the United States and the Department of Justice. And we're talking about the conference room where we give press conferences and similar public statements. And I felt it was fundamentally...
Mr. Ritz, that doesn't fly. Mr. Chairman, I've got the sex abuse quote. I'll submit it for the record. Thank you, Mr.
Mr. Ritz, you've been asked several questions but not given the chance to answer them. Would you like to respond to any of the questions raised by the senator?
I think, I can't remember which one I was not able to answer. At this time, I'm happy to move on.
All right. Senator Butler?
Thank you so much, Mr. Ritz, and congratulations
Thank
to
you, Senator.
for being nominated and appreciating your family and supporters. I know it takes all of us to make sure that we get to, that you have the opportunity to get to that table. So
No doubt about that.
them, for their support. There's been a number of questions sort of peppered at you, and I appreciate the passion of my colleagues. One of the things that I found important as I was reading your packet of materials was that, you know, as an AUSA and U.S. Attorney, you've participated in community anti-crime programs, intervention and prevention initiatives, and efforts to facilitate reentry for those returning to the community from prison. I also noted that you received what I consider to be a stellar letter of recommendation from the Federal Law Enforcement Officers Association, and it reads in part, and I quote, "We simply can think of no better candidate for the Sixth Circuit who is as well known to the federal law enforcement community and well known to the people of the Western District of Tennessee than Mr. Ritz." Mr. Chair, I'd like to enter this letter of support into the record. Mr. Ritz, as U.S. Attorney for the Western District of Tennessee, you've played a crucial role in law enforcement and community engagement efforts. If confirmed, how do you plan to use your experience in working with diverse groups and stakeholders to ensure fairness and impartiality on the bench, as was referenced in questions you got earlier?
Thank you, Senator. Fairness and impartiality are at the core of what I've done in my career as a federal prosecutor and as United States Attorney. Of course, it's a different role when you're an advocate for a client, which I've been my whole career, than being a judge. And I've been in front of numerous federal judges, from the magistrate court to the district court to the Sixth Circuit. And what I've seen from those judges is a committed fairness and a diligence about being open-minded and neutral with regard to the arguments and facts before those judges. That's the type of approach I would seek to bring, is that neutrality and impartiality. I have certainly, and you referenced the diversity of community stakeholders that we work with in the U.S. Attorney's Office. I've learned so much from them, and I'm from Memphis and have lived there for most of my life, but I've learned so much more since being United States Attorney and visiting different areas of our district and different areas of Memphis. And those diverse perspectives have helped shape my views on fairness.
Thank you for that. I also noted in your robust packet of materials preparing it, you're a man of faith.
That's correct.
Serving as a deacon in your Presbyterian church. Maybe you can inspire Senator Booker when he comes to serve. How do you believe your faith and your involvement in your religious community has influenced your perspective on justice and fairness and ethical decision-making?
I appreciate the question, Senator. Faith is a big part of who I am. It certainly has shaped my sense of right and wrong, along with my mom and dad's teaching, and they're sitting right behind me. And, you know, I certainly have not let my personal views impact my work as a lawyer for my client, and I would not let my personal views impact or my faith impact my decision making as a judge. But it's certainly a big part of who I am, and as I would like to think set inside of me a moral compass.
Thank you so much, Mr. Ritz.
Thank
you, Mr. Chair.
Thank you, Senator. Senator Lee.
Thank you, Mr. Chairman. Thanks, Mr. Ritz, for standing for this nomination and for being here today. Now, it's my understanding that you were subject to an ethics investigation by OPR. Is that right?
Never in my career.
Never. But you're aware of the situation in United States versus Von Rico Weber, where you were accused of making these material representations to a defendant's attorney in order to elicit a guilty plea.
I have some recollection of that, Senator, but I was not subject to any sort of formal complaint or investigation.
Okay. Well, it's my understanding that in this circumstance, this would have resulted in the defendant serving a 10-year prison sentence, and the accusation is that you led the defendant to believe that a low sentence, a much lower sentence, would be in order, or perhaps even probation. I just want to read to you the letter, the email that we received from the concerned defense attorney, shining light on the incident. The person writing this email is recounting a conversation with the defense attorney in which you allegedly misled the defense attorney and the defendant. After the defense attorney explains it. Here's how he explains it. At this point, I stopped the conversation and said, "Was the AUSA Kevin Ritz?" The answer was yes. It is unfortunate that this is not the first, second, third, or whatever occasion that this sort of thing has occurred, but everyone should be aware of this unfortunate pattern of behavior. You should be aware, your clients should be aware, and you should proceed with extreme caution. It is a sad commentary. This is a concerning allegation, of course. Now, I assume that you would agree, certainly, that misleading a criminal defense counsel as to the nature of the charges against the defendant and the likely sentence that might result from a guilty plea that would violate a federal prosecutor's ethical responsibilities.
Yes, and I did not do that in that case, Senator.
Now, my understanding is that a complaint was made against you with the Department of Justice Office of Professional Responsibility and that an investigation ensued. At what point did you become aware of that investigation?
Again, Senator, to my knowledge, there was never an OPR investigation, or a complaint for that matter.
Okay, so you're not aware of anything like that?
That's correct.
Does the information you just heard, the accusation, does that reflect your pattern of behavior as a prosecutor?
Absolutely not. And I recall this, and I recall that the person who had sent that email communication certainly had not communicated with me. I'm not actually sure we had ever had cases together in the first place. In any event, I took action, and I believe I communicated with everyone who received that, because in our federal district, it's really important for AUSAs and defense attorneys to be able to trust each other. And sure. I took my reputation very seriously.
Okay, but you would agree that if you had done those things, which that had resulted in a complaint to OPR and you didn't disclose it, either of those things would be a problem?
If I had acted unethically, absolutely, but I did not.
Now, as you know, one of the most important decisions a U.S. attorney can make is the decision about whom to hire as a first assistant U.S. attorney. Would you agree with that?
Yes.
It's a pretty important thing. And it's why I find it disturbing that you chose to hire Ms. Reagan Taylor Fondren to serve as your first assistant, despite the 2 disciplinary investigations that she was under for serious accusations relating to ethics violations. As a former federal prosecutor myself, I know that the fairness of the justice system depends a lot on, among other things, how prosecutors handle things like exculpatory evidence. And withholding exculpatory evidence from defense is a big problem. Ever since Brady versus Maryland was decided in 1963, every prosecutor knows that there is an obligation to disclose these things. Now, when you chose Ms. Taylor Fondren to be your first assistant, were you aware of the 2 ongoing investigations of her alleged prosecutorial misconduct related to failure to disclose exculpatory evidence?
I may have been aware of ongoing proceedings. My recollection, Senator, they were not. They were still proceeding, and I honestly can't remember if they still are today.
So they were pending at the time you chose her. Were you not concerned about that?
Senator, I am not sure I knew the particulars of the situation.
In fact, she began your service as a first assistant before her court-ordered suspension from legal practice was enforced. Is that right?
I believe that's correct, Senator. I'm not actually entirely sure.
Now, a man served 4 additional years in prison because of the misconduct of your first assistant. Now, thankfully, the Court of Appeals corrected her error, but not for the full 4 years. And so, was it in spite of or because of Ms. Taylor Fondren's willingness to violate the defendant's constitutional rights that you chose her to be your first assistant?
Senator, as I said before, I believe that Ms. Fondren and all of our AUSAs are doing an excellent job keeping people safe in West Tennessee. These allegations and this incident occurred, I want to make clear, before Ms. Fondren was part of our office several years ago.
But you were aware of the accusations?
I was aware in a very vague sense.
Thank you, Senator Lee. At this point, I'd like to put in the record a letter from Van Turner. Are you familiar with him, Mr.
I am, yes.
He characterizes himself as chairman of the NAACP Tennessee State Conference Legal Redress Committee, writes to the committee and says, I implore you, Senate Chairman Durbin and the Committee on Judiciary, to ratify the nomination of Kevin Ritz to serve on the U.S. Court of Appeals for the Sixth Circuit. He is qualified, he has the temperament, he has the work ethic, he is ready to serve. Oftentimes, candidates may not have everything just right when seeking these kinds of appointments. This is not the case with Attorney Ritz. I cannot think of a better fit and a nominee for this role on the Sixth Circuit than Kevin. And we hope and pray that you see it the same way and agree as well. Senator Ossoff.
Thank you, Mr. Chairman. And Mr. Ritz, to you and your family, congratulations on this extraordinary nomination.
Thank you, Senator.
Appointment to the appellate court. Will you pledge to faithfully apply the law without bias, without regard for your personal policy or political preferences?
Yes, Senator.
Why is that vital for a federal judge?
It's vital for so many reasons: to ensure trust in the system You want all of our judicial officers to be acting neutrally and faithfully to the law without regard for their personal preferences or views.
Why and how, in your view, is the First Amendment so essential to our constitutional system, and how will you approach cases that implicate the First Amendment should you be confirmed?
Senator, thank you for the question. The First Amendment is one of our bedrock principles of our Constitution, both in the religion clauses, the speech clauses, and freedom of the press. These are principles that are core to what we are as Americans, in my view. If I were confirmed, I would faithfully apply the precedents of the Supreme Court and the Sixth Circuit on those principles and the First Amendment to the cases before me.
Let's talk about indigent defense and access to counsel. Why, in your view, is the Sixth Amendment protection for access to counsel, the precedent established by Gideon v. Wainwright, so important, and how, in your legal experience, has that mattered in the courtroom?
It's mattered so much, Senator, as someone who spent the majority of my career doing federal criminal work. I've had the privilege of being in court with so many talented opposing counsel, defense counsel in the Federal Public Defender's Office and elsewhere. They are terrific in West Tennessee and at the Sixth Circuit, I should say. I've learned so much from them about the job that they've done representing the interests of their client, about what that Sixth Amendment principle means and what it looks like in practice. As I said, I pride myself on my relationships with those individuals and my reputation with those individuals. In fact, you mentioned Gideon, and I believe it was the 50th anniversary of Gideon. We had a program in Western Tennessee where the judges and the federal public defender and myself, this was before I was U.S. Attorney, we commemorated the Gideon case by acting out some of the proceedings that had occurred in that case. And it really drove home for me just how much of a bedrock principle that is in our Constitution.
And should you be confirmed, will you make every effort as appropriate and consistent with precedent law and the Constitution to ensure that every party in your courtroom has the representation they deserve?
Absolutely, Senator, absolutely.
Let's talk about language access. Parties who come before the court, whether or not English is their first language, deserve equal access to justice. What's been your experience with language access challenges and barriers, and how will you approach them should you be confirmed?
Certainly, Senator. I've had experience when I was trying cases in trial court where there were interpreters necessary, mainly Spanish-speaking interpreters in the cases I was handling, but some others as well. Our district court in West Tennessee, in my view, does an excellent job of providing those services to those who need them. So it really taught me just how important it was, again, for someone who is in a courtroom and there's a strange language being spoken, and they're obviously the subject of this proceeding, how important it is just for that language barrier to be broken down so that they can understand what's going on.
And you will, to the best of your ability and consistent with the law, be sensitive and attentive to the needs of parties who may become before you with respect to language access in the courtroom, but also for the surrounding efforts and proceedings?
Absolutely, Senator.
Thank you, Mr. Ritz. Thank you for joining us today.
Thank you.
Senator Hawley.
Thank you, Mr. Chairman. Mr. Ritz, I'm quite confused about this ethics issue or issues, so maybe you can just help me sort it out. So I don't think I maybe understand the facts here. So you said that you've never been subject to an ethics complaint before. Is that right? I
said, to my knowledge, never been subject to an OPR complaint or any sort of formal complaint.
Okay. I'm looking at a letter from May 16th, 2010 to the Office of Professional Responsibility that reads, "This letter is a formal request that your office investigate matters pertaining to the fair dealing and, more important, honesty of Assistant United States Attorney Kevin Ritz."
If that letter exists, Senator, I was unaware of it until just now.
But you're aware of the issues surrounding the Von Rico Weber case, which is the subject of this letter asking for a formal investigation into you. You're aware of that?
As I said, I do have some recollection of that matter.
Oh, okay. So you were subject to a complaint. I have the letter right here. let's just try to figure out what's going on in this case. I mean, this was a case involving a public defender who you got a plea agreement with, and then she asked to withdraw as counsel because she said you misrepresented the situation to her, and the court granted her motion to withdraw as counsel. That's pretty unusual, isn't it? I mean, what's happening here? She said that you told her that she relied on information about the nature of the crime, which was, she was told, was going to be a marijuana trafficking offense. And then when she got the PSR, it had a base offense level of 34 because the underlying offense was cocaine trafficking. So she had advised her client, based on your representations, here's what you're going to be likely subject to. They accepted the plea deal. She looks at the PSR, and it's something very different, she says, than what you told her. Now, this is a public defender now. And so on that basis, she had to withdraw as counsel, and the court granted her request. That's very unusual. I mean, what happened here?
Senator, first of all, I believe it was not a public defender. It was a defense attorney on the CJA panel in West Tennessee. There was a written plea agreement that was entered into. That written plea agreement, as with all of our plea agreements, includes a provision that says these are all of the promises made to this defendant by the government.
Yeah, but neither the indictment nor the change of plea transcript nor that agreement says anything about the underlying crime. It just says funds were the proceeds of distributing controlled substances without any specification of the alleged illegal narcotics. So what she says is, you sandbagged her, basically.
And that's not true. I made no such promise along those lines. It's
but
not
was
true.
there any indication before the PSR that you were going to hit this guy with the cocaine? I mean, this is unusual. It's unusual to be a Democrat administration nominate somebody who is accused of, who's hated by federal public defenders, and who's accused of sandbagging indigent defendants. So I'm baffled by this. I am totally baffled by this. So I'm trying to figure out what in the world happened. And then you got taken off this case, I think, right?
My recollection, Senator, is that the office had someone else handle it in case I needed to be a witness at a proceeding.
Well, here's what Vivian Donaldson, who is the counsel who ended up representing the United States, at Ms. Chastain's motion to withdraw as counsel, here's what she said. These allegations about you are serious. That's one of the reasons I am here, meaning in court, and Mr. Ritz will more than likely be taken off this case because of these particular allegations. So did that happen?
And I believe it was in case I needed to be a witness. But those allegations...
This is what your supervisor said in open court. I'm not quoting you now a private letter. I'm quoting you something from open court. She says you were removed from the case because of the allegations, which she says were very serious. Now, you've represented this committee. You knew nothing about all of this. You answered a question in the committee questionnaire that you weren't aware of any complaint. You weren't aware of any disciplinary committee. You weren't aware of any inquiry ever. But yet, I'm reading you a transcript from open court in which your supervising attorney says the allegations against you are very serious and you're going to be removed. So I have to tell you, I don't think I'm trying to figure out what in the world is going on here, because it doesn't sound to me like you've been very forthcoming, certainly to this committee. So what happened? Were you removed because of the allegations of improper behavior?
The allegations were false, first of all.
I'm not asking you about your view. I'm asking you about what you told the court and about what your supervising attorney told the court.
And I don't recall exactly why there may have been a change in counsel.
Mr. Ritz, don't you think you'd want to, don't you think that's kind of important information?
These allegations were false, and there was never a finding.
You have a clear memory of that, but you don't have a clear memory of what happened in open court and you being potentially removed by your supervising attorney. This is very bizarre, I have to say. I've never seen it quite like this. This is very, very strange. And I just noticed that we have a sudden instance of amnesia anytime we're dealing with the actual ethical complaint, but you seem to remember the case exceptionally well. So this troubles me, and it's strange. It's very, very strange. Maybe my Democrat colleagues can clear this up. I'm sure they've vetted you. This is very, very odd. So your testimony is you weren't removed. All of this was false. You were never investigated, and this just all went away, or what happened?
There was certainly no court finding or any other finding by an investigative body of any unethical behavior.
I thought the court then allowed this defendant to change his guilty plea. He'd pled guilty, and then the court allowed him to withdraw it. That's also very unusual.
It does happen from time to time, Senator.
On the basis of your misrepresentations.
That was not the finding of the court.
Thank you, Mr. Chairman.
Senator Whitehouse.
Welcome to the committee, Mr. Ritz.
Thank you, Senator.
A little background here. We have, on rare occasions, had nominees come forward without blue slips from their home states. It is quite rare, and you are one, and that may explain some of the activities here in the courtroom. I simply want to remind everybody that when our Republican friends decided that they were going to no longer honor circuit court blue slips, I over and over urged them to please don't go there, because turnabout is fair play, and you will have no cause to complain if you ram circuit court judges through against the wishes of the Democratic senators for the jurisdiction. I see Senator Butler here. There was one judge rammed through in California who was so remote from California that Senator Feinstein refused to treat the individual as actually being from California. It was just somebody like chosen out of the world to go and be shoved into California with no blue slips from her. So you are in the middle of a bit of a quarrel over circuit court blue slips that began long before you got here and that started with our friends on the other side. I want to ask you about two what I think are pretty important safeguards for the judicial function. One has to do with where fact-finding gets done. We've seen very strange instances of the Supreme Court engaging in fact-finding at the very end of the case, after all the arguments are done, in the secrecy of their own chambers. Suddenly they come up with facts that are not in the record anywhere that are pretty essential to the disposition that they bring to the case. In your view, where does the fact-finding function belong in the American judicial system?
Senator, it belongs in the at the district court level, and whether the fact finder is the judge or a jury, that is where it belongs.
And that's because the adversarial process can test the facts, that there's trial time to develop the facts, there's a neutral judge to decide the facts, and if the judge should get it wrong, there's at least a chance of appeal, even though factual appeals are disfavored, correct?
And that's correct. One way I've thought about it, Senator, is that, the people in the courtroom at the district court level are the ones seeing the witness testifying and can determine whether that witness is telling the truth or not. Right?
Yeah. And the other thing has to do with the role of the jury. My view is that the Supreme Court has rather diligently been trying to undo the role of the jury and allow all sorts of ways, particularly for corporate defendants, to get around jury trials by requiring that they agree to private proceedings instead of a public trial and so forth. And I just wanted to get your view on this as well. I go back to, Blackstone and the founders who talk about the importance of the jury as actually a means of governance. Mm-hmm. That this is a way in which regular people get a chance to have a say in their own governance, and it also protects government against the power of wealthy and powerful interests, because every jury comes in new. You don't have a chance to influence them. If you try, it's a crime. It's called jury tampering, whereas people try to tamper with our branch of government nonstop. Lobbyists are paid fortunes to do that. People pour money into congressional races to do that. So to me, the jury is very important as a check against power and wealth, and as a means for the engagement of the community in important government decisions. And I'm interested in your views on that.
I completely agree that the jury right is central to our system, Senator, and of course it's constitutionally protected in the Sixth Amendment and in Article 3. I think it's the only right that's been in both the body of the Constitution and in the amendments, that the right to jury in criminal trials, and of course the Seventh Amendment right to jury in civil trials. I have seen it, the bulk of my experience, of course, has been in criminal cases, and the bulwark that you were kind of alluding to, I see it, of course, in our cases, where there is a jury of peers that stands between the government and this person's loss of their freedom, and it's crucial.
You can get powerful entities like Fox News and like a former president and like InfoWars who are brought into a courtroom and suddenly have to be accountable for the first time, and it makes a very big difference. Thanks very much, Chairman.
Thank you, Senator Whitehouse. Senator Kennedy.
Thank you, Mr. Chairman. Mr. Ritz, you are a political activist, aren't you?
I would not consider myself that at all, Senator.
Okay. When you were sworn in as U.S. Attorney, you gave a speech, didn't you?
I did.
Okay. Here's what you said. I'm going to quote from your speech. But you should know that justice for me is about more than putting people in prison. For me, it's also about who votes and how hard it is to cast that vote. It's about where pipelines go. It's about where bus routes go. Justice is about whether people in all zip codes can get along, whether women have access to health care, whether citizens have affordable housing or clean drinking water. Sometimes those are Department of Justice issues. Sometimes they are not. But for me, they're all justice issues. Did I read that accurately?
I believe so, Senator.
Okay. Did you really remove the Tennessee state flag from your conference room?
Senator, I appreciate you asking about this again. As the chief federal law enforcement.
Welcome. Did you do it?
So I felt it was fundamentally inappropriate when I gave press conferences and similar statements to the public to indicate or suggest somehow that I spoke for the state, which I don't under our system of federalism.
Are you embarrassed to be from Tennessee?
Not at all, Senator. I am from Tennessee, grew up as a public school kid in Tennessee.
But you were embarrassed to have the Tennessee flag.
That's not it at all, Senator.
Okay. You have a history of lying to your professional colleagues, don't you?
That's not true, Senator.
Okay. Do you know a former public defender named Stephen Shankman?
I knew him to a degree. I'm not sure we ever had any cases together. I knew who he was, yes.
Well, in a private email, not meant for public consumption, to another one of your professional colleagues, this is what Mr. Shankman said, talking about your lying. He said, "It is unfortunate that this is not the first, second, third, or whatever occasion that this sort of thing has occurred. But everyone should be aware of this unfortunate pattern of behavior. You should be aware," he said to the other lawyer, before the other lawyer dealt with you. "Your client should be aware, and you should proceed with extreme caution." Was Mr. Shankman lying?
To the degree he suggested that I acted unethically, that was not accurate, and it wasn't in any occasion, much less on numerous occasions.
Okay, let's talk about this case, United States v. Von Rico Weber, which you claim to not remember. But before I do that, a few seconds ago, you lied to Senator Hawley, didn't you?
I'm under oath, Senator. I did not lie.
You said you have no knowledge of any complaint, professional complaint made against you, didn't you?
I said I have no knowledge of any sort of formal complaint, and he read from a letter that I don't believe I ever saw.
And you were shocked. You never heard of that before.
If there were a formal complaint, that, as I said, I had not known about that.
Okay. You were amazed.
I don't recall any of that.
I
recall this Mr. Weber's
case. You have amnesia about
it. Again, I am unaware of any formal complaint or investigation. Certainly was not.
You believe in the Tooth Fairy?
Senator, I don't.
You believe in the Easter Bunny? Now, in this case, United States v. Von Rico Weber, you lied to the defense counsel. And the defense counsel then had to go before the court and withdraw a plea for his counsel. And a complaint was filed, about which you apparently have amnesia. and the Justice Department replaced you. And the lawyer from the Justice Department who replaced you, this is what the lawyer said. The new attorney said about you. Said these allegations against Mr. Ritz are, quote, serious. And it is taken so seriously, referring to the Department of Justice, by our office. That is one of the reasons I'm here, and Mr. Ritz will be more than likely be taken off this case because of those allegations. End quote. You lied to Senator Hawley, didn't you?
I didn't lie to the defense counsel in that case. I didn't lie today, Senator.
Now, my good friend Senator Ossoff asked you if you'd follow the law. And you said, yeah. But if you're lying to us today, we're stuck with you, aren't we?
Senator, I have not lied and did not lie in that case.
You just have amnesia.
I did not lie in that case. There was a written plea agreement with the entire agreement of the parties.
If you believe that, you believe Elvis is alive and running a small bait stand on Lake Erie. Shame on you.
Mr. Ritz, I asked our staff here who review all sorts of nominees' qualifications and backgrounds, how it would be possible that someone could file a complaint against someone and they didn't know it. They said it is not uncommon at all for OPR to decide not to act on that letter of complaint and not to proceed with it and not even to notify the person accused.
That's my understanding as well, but again, yes.
We think that's a fact. So this notion about amnesia or whatever it may be, it is credible, at least possible, that exactly as you portrayed it, they never notified you. Senator Booker.
Thank you, Mr. Ritz, for being here. I really appreciate you putting yourself forward. You've lived your entire life. I've looked at your CV, and I just found it interesting that you never worked in a private law firm. Is that true?
That's correct, Senator. Other than, I should say, being a summer associate.
So, I'm kind of wondering why you've dedicated your entire life to public service when you could have broken away at any point of time and made enough money to perhaps pay off loans or made enough money to perhaps, we see lots of judges come here before us, and you're a rarity. You've dedicated your entire life to public service. Can you explain that to me?
My entire life, Senator, thank you for the question, to public service in service of our country. And it was instilled in me as a child, whether it was being an Eagle Scout or otherwise, to have pride in our country and how important it was to give back to your community. And
I'm sorry, but your career, from the time you were like not even a teenager, you've been this outstanding, sort of example, leader, recognized amongst your peers, Phi Beta Kappa. I'm glad my mom isn't here because she'd look at me and say, why didn't you have as good grades? And yet you never got pulled into something that would make your life a little bit more financially comfortable.
And Senator, it is true that I had opportunities to do that. Many of my colleagues in the U.S. Attorney's Office can say the same thing. And it's been such a fulfilling career to work side by side with them, with our team, our law enforcement partners, of course, in service of this greater goal of upholding the rule of law and keeping people safe.
Yeah, and that's interesting to me because law enforcement, there's a lot of aspersions cast on law enforcement as a profession. You and I have had a chance, I imagine, to work with a lot of people in law enforcement and seen sort of their heroic work. Why take this career path through being a prosecutor, being a part of, basically, arm of the law of our country?
I'm not going to say I fell into it, but it certainly seemed like a great pathway to kind of move back to your hometown and be an AUSA. It's kind of the best of all worlds. Obviously, you get really good experience as a as a new prosecutor, and whether you're in state or federal court, and that was certainly the case. I was thrown into things, but to work with law enforcement officers, I can say there were Memphis police officers on my cases who I'd gone to high school with, and just being a part of that community and serving that community every day to try to keep people safe. And I've certainly broadened that portfolio past Memphis to the other 21 counties of our district, and taken that responsibility very seriously to make sure we're being intentional about serving the citizens in all 22 of our counties.
And you understand clearly through your career what it means to be a patriot. You demonstrate that with the choices you made with your life, what it means to have integrity within law enforcement and how scrupulously disciplined you have to be in the conducting the law. You seem to understand what it means to be humble in your service. And yet law enforcement often gets attacked. You knew you were coming before a Senate committee. You knew you were going to be roughed up. But I wonder what it feels like to live your life with these values, to be the center part of your being, from the letters I've read and the like, to be called a liar or to be accused of these things. How does that make you feel?
Senator, whatever I feel would pale in comparison to my colleagues in federal, state, and law enforcement who are on the front lines and deal with, no offense, much more serious risks to their well-being and livelihoods than I am here today, of course.
Right, and you probably had in law enforcement, you get questioned from the people on the left and the right.
Yes, we do.
Yes, and I imagine when you wade into difficult issues that do get the public eye, like the Tyree Nichols case, I'm sure you were questioned during that period as well.
Yes, Senator, and all I can say is with every decision that I've made as United States Attorney, it's because of what I felt was in the best interest of the United States and the best way for us to uphold the rule of law without fear or favor to anyone.
So bullying or name-calling or critiques from the left or the right, the politics of the day about law enforcement, you hear all that noise, but how does it affect your work?
I think you keep your head down and work day to day to fulfill the mission of the department, and I'm proud of our team for doing that. We obviously don't get involved in politics. We uphold the rule of law in a neutral fashion.
And lastly, there are a lot of things. I've never obviously served in the judiciary. A lot of things said that are important values for judges. You've been before a lot of judges before. Can you just maybe summarize finally, what do you think to you, when you've looked towards the bench, what is the most important values that a judge has?
I think it's really important for judges to be open-minded and in a meaningful way engage with the arguments being raised by the parties, even if it's something that you may have seen 100 million times before. A diligence about going through the record, of course, as an appellate judge, really getting your hands into the record of what happened below. And finally, a scrupulous fidelity to the law and to the legal precedent.
Well, I just want to thank you. I won't necessarily get this opportunity again to look you in the eye and tell you how humbling it is to me, how you've chosen to live your life with your gifts, with your qualifications, with your excellence, the fact that you have shown a fidelity to the law and shown a love of community, a love of your state, and a love of this country. It's not exhibited in your words. It's an exhibit in how you've lived, and I'm grateful that you're an American and grateful that you want to do this job. Thank you.
Thank you.
Mr. Ritz, this ain't beanbag. It's at the highest level for a lifetime appointment to a critically important court in our nation. So you can understand that the seriousness of the matter that we've addressed today. I'm sorry for some of the words that were used, particularly anyone who characterized you as a liar because of this complaint before OPR. We've drawn from their website a statement which I'd like to ask unanimous consent to put in the record. And here's what it says. Most complaints received by OPR are determined not to warrant further review because, for example, the complaint appears on its face to be without merit, is outside OPR's jurisdiction, or is unsupported by any evidence. This is the critical sentence. In such cases, OPR will close the matter without informing the subject attorney of the complaint. So your statements are at least in the realm of credibility as far as I'm concerned, and certainly don't merit any characterization as a lie. I'm sorry that you were subjected to that. Senator Cruz?
Thank you, Mr. Chairman. In your 2023 U.S. Attorney Investiture speech, you highlighted the challenges you believe America faces and what justice means. You said, quote, "We're experiencing a long overdue reckoning with racism in the criminal justice system." Mr. Ritz, what part of the criminal justice system needs a long overdue reckoning?
Senator, what I was describing were a number of things that have happened in recent years in this country that framed, I would say, in some ways, the work that we do in the U.S. Attorney's Office.
Is the American justice system systematically racist?
That is not a sentiment that I hold. To the degree there is a definition of what being systematically racist means, I understand some individuals have pointed to disparities in sentencing and that type of thing, but that's not a view that I have.
So that's not a view that you have. That was your testimony. Well, you also said, quote, "There cannot be one rule of law for people who look like me and another for people of color." That sure sounds like the view you just said you didn't have. Do you believe that's our system, that our justice system has one rule of law for people that look like you and a different rule of law for people of color?
No, what I said is that absolutely we cannot have one rule of law for people who look like me and another for people of color. We cannot have one rule of law for the powerless and another for the... There's just one rule of law. That's what I said.
You also said, when asked if the criminal justice system is systematically racist, you said, quote, "There are structural barriers and disparate outcomes that communities of color experience in our society, separate and apart from any individual's views or intentions." Now, that again seems to be saying the same thing that you're saying you weren't saying. I'm just trying to understand what your views are.
And Senator, that was my attempt in that written question to grapple with, again, what was being asked by systematic racism. I understand some have pointed to structural barriers and disparate outcomes.
So what are the barriers and outcomes you're referring to?
I can think of one prominent example that I've had some experience with, which is the disparity in cocaine sentencing between crack sentencing and powder sentencing. This body has addressed those disparities on multiple occasions, and that has been, as I understand it, something that people have addressed as a result of disparities.
Okay, you also said in responses to questions for the record that, as the Attorney General has explained, everyone has implicit biases. So what are your implicit biases?
Senator, I understand implicit bias to refer to unconscious bias that exists below the level of consciousness, and so to the degree I have implicit biases, I think we all do. I think that's partly the point. Is
so everyone's a racist whether they know it or not?
And that's, I would say that everyone might have implicit biases, and I don't know what.
So what's the difference between bias and prejudice?
I think there can be a lot of overlap in those things. It depends, I think, on the context.
So you're saying everyone is prejudiced?
That's not what I said, Senator.
You just said everyone has implicit biases, and you said that bias and prejudice, I think your words were, there's a lot of overlap.
I think that's right, and I understand implicit bias, and I'm not an expert on the subject, to refer to a set of biases that may exist under a conscious level.
So, since you talk about these implicit bias issues, have you taken a so-called implicit bias test?
We received training that was put on during the last administration in our office on implicit bias. I attended that training in our office.
And what did you take a test?
I don't believe there was a test associated with that, Senator.
Okay, you also said, quote, "But you should know that for justice, for me, is about more than putting people in prison. For me, it's also about who votes and how hard it is to cast that vote. It's about where pipelines or bus routes go. Justice is about whether people in all zip codes can get a loan, whether women have access to health care." That's an interesting statement, and in reading it, what's striking is that that's de-emphasizing the core role of a U.S. attorney. The last I checked, a U.S. attorney is not in the policy business of deciding where pipelines go. That's the role of environmental activists and left-wing activists, but is not supposed to be a U.S. attorney. Why was your focus elsewhere?
Senator, and the very next thing I said was that those are not issues that we deal with on a day-to-day basis in the U.S. Attorney's Office, where we are primarily focused on enforcing criminal laws. I was seeking to place justice as a broad concept at the center of, to place our work within justice as a broad concept.
So do you agree that Memphis is one of the most dangerous cities in the nation?
It is. We have an intolerable amount of violent crime, and that's why there's no higher priority for us in our office.
Well, there's no higher priority except for pipelines, except for bus routes, except for bank loans, except for implicit bias, except for the fact that everyone is prejudiced. All of those other things are what you're focused on talking about instead of actually locking up bad guys who are murdering and raping and hurting people.
In those same comments, Senator, I said that we don't apologize for seeking significant prison sentences, and that's at the core of what we do. When we have serious violent crime, we seek serious sentences and consequences.
Thank you.
Thank you, Senator Cruz, and thank you, Mr. Ritz. We appreciate your being here. You may have received some questions in writing. If you'll respond in a prompt fashion, we'd appreciate it very much.
Thank you.
We now make room for the second panel. If you'll please stand and raise your right hand. Do you affirm the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that all three nominees, thank goodness, have answered in the affirmative. I'm not sure what we'd do if you didn't, but we will proceed. You each have 5 minutes for an opening statement. Mr. Murphy, you're first.
Good morning, and thank you, Chair Durbin, and members of the committee. I am humbled to be here this morning. Receiving this nomination has been the honor of my career. I would like to thank President Biden for nominating me. I also want to thank Senators Warren and Markey for their support of my nomination and for their kind words for me this morning. I want to acknowledge the great number of family members who have supported me throughout my life, and many of whom are here with me today. I am joined today by my wife, Lindsay Heffernan. She has been my strongest supporter, and she has been my closest confidant and best friend for the last 25 years. I'm also lucky to be joined by my 3 wonderful children. I am thrilled to have my children be able to see the Senate in action, and I look forward to viewing the Constitution with them later this week. I am fortunate to be surrounded by a loving and supportive family my whole life. I'm lucky today to be joined by my parents, who have strengthened me and been my biggest cheerleaders. They instilled in me both the importance of education and of public service. I'm also lucky to be joined by my sister, Shannon Dandridge, as well as my niece. I know my sisters, Kara and Kristen, are watching from home. I'm also grateful that my brother and sister-in-law, Neil and Christina Heffernan, have been able to join me today. I'm lucky to have a large, extended family who is watching at home, and I want to thank them for all the encouragement they have always given me. I also want to acknowledge my close friends and neighbors, the Molinas, who were able to join us today. I also want to thank my professional community. I know my friends from the legal community are watching this online, and their support has been invaluable. I want to specifically thank the members of my law firm. I have been privileged to work with some of the best legal minds, and they have constantly helped me grow as a lawyer. Thank you for the opportunity to be here today and for considering my nomination, and I welcome your questions.
Thank you, Mr. Murphy. Judge Pinnell.
Thank you. Good morning, and thank you, Chair Durbin. Thank you to the committee for holding this hearing today. And I'd also like to thank my home state senators, Murray and Cantwell, and especially Senator Murray for her warm introduction. I'm so thankful to President Biden for this nomination. It is truly the greatest honor of my professional life. I'd like to recognize those who are here with me today. First, my husband, Tom. Tom, I could not be here without all of your love and support. Also here is my daughter. Sweet girl, you are the light of my life, and you inspire me to be a better person every day. Also here are my father, Bill, my siblings, Shelley and Michael. My dad is my sounding board for all things in life, and my siblings are my great friends. It means the world to me that they've traveled from far and wide to be here today. My sister, Catherine, and my stepmother, Sandra, couldn't be here today, but I know that they are cheering me on from the West Coast. I love you all, and I'd also like to thank my first law clerk, Haley Dean, who's here today, present with her support. Finally, I'd like to recognize my mother, Mary. Mary was taken from me and my family at far too young an age. Her commitment to hard work and public service have been a guiding force in my life. My mother loved Washington, D.C. and all of its history. She is surely smiling down on me today. I'd like to thank my friends and colleagues who have supported me throughout this process and who are watching today. To my Washington State Court of Appeals family and court staff, your dedication to public service and the administration of justice is inspiring and appreciated. To my friends, especially those back home in Yakima, Washington, thank you for your support and your belief in me. I've had the privilege of starting my career clerking for the Honorable Robert Whaley in the U.S. District Court for the Eastern District of Washington. The federal bench in Eastern Washington has always been like a family to me. It would be a great honor to return to that family at this point in my career, should I be so fortunate to be confirmed. I look forward to answering the committee's questions.
Thank you. Ms. Vargas?
Thank you, Chair Durbin, Ranking Member Graham, and all the members of the committee for holding this hearing today. My thanks to President Biden for this nomination. While I'm not the first on this panel to say it, it bears repeating that this is truly the honor of a lifetime, and I feel humbled and grateful. Thank you to my home state senators, to Senator Gillibrand, who recommended me to the President, and for her kind words of introduction here this morning, and to Senator Schumer for supporting my nomination. I'm so grateful to Justice Sonia Sotomayor, for whom I clerked when she was on the Second Circuit Court of Appeals. Without her guidance and mentorship, I would not be where I am today. I became a lawyer because of my abiding interest in serving the public. And as an AUSA for the Southern District of New York for the past 2 decades, I've gotten to do exactly that. But to do so while also working with the brilliant, talented, and dedicated attorneys and support staff of the Civil Division has been the real gift. The SDNY Civil Division is a special place, and the people who work there are true public servants. They're even truer friends, as demonstrated by the fact that a contingent of them have come here today to support me. Not everyone in my life could be here today, however, so I'd also like to recognize my family and friends who are watching this hearing from home. In particular, I'd like to acknowledge my brother Steve, my sister-in-law Tori, my nephews, my niece, and my in-laws who are watching this hearing from India. I love you all, and even though you couldn't be here today in person, I know you're cheering me on from afar. My thanks to my parents, Joe and Peggy, who are here with me today, as they have been through every important moment of my life. My parents have been my biggest sources of inspiration. They fully believe that if you work hard, you can make something of your life. And they didn't just believe that, they modeled that for me and my brother every day as we grew up. And I'm so grateful to them and for all they've taught me. To my 2 wonderful children, Kathan and Estelle. Estelle, you blow me away with your talent and creativity. You challenge me. You inspire me with your passion. Kathan, I love your kindness, your empathy, your humor, and the clear-sighted and logical way that you see the world. And finally, my husband, Shiv. You've been my partner in life for the past 30 years and the best friend that I could have ever hoped for. You've been my most enthusiastic cheerleader. You have always encouraged me to dream big and then to dream even bigger. Without your support and willingness to take the laboring oar when I was not able to do so, I would not be here today. I'm so grateful to have you in my life. Senators, I welcome your questions.
Thank you very much, Ms. Vargas. Let me say for the record, what is already part of the record, but I want to say it publicly, that these 3 nominees, like the one before them, have all been found to be unanimously well qualified by the American Bar Association. That involves, as I mentioned earlier, interviewing a number of people professional and otherwise, to comment either confidentially or for the record on the person's background and their temperament and their ability to serve in this capacity. A unanimous, well-qualified finding is the highest it comes, and I wanted to make that part of the record. So, Judge Pinnell, there's this part of your life where you were dealing with drug entry court. I have seen those courts used successfully in Illinois, in Chicago and Cook County, dealing with veterans and people with special disability situations. What was your experience?
Thank you, Senator, and thank you for the question. Drug courts are exceedingly important for public safety. My experience with drug court was in the federal context, where we had a reentry court for individuals leaving federal prison. We, in my part of the state, do not have a reentry center, a federal reentry center, so folks would come out of federal prison straight to the streets. But for folks with a substance abuse disorder, they could come into our step-down program, we call it the STEP program, drug court program, if they had a substance abuse disorder where they had more intensive supervision. We had a team made up of public defender, U.S. attorney, probation officer, treatment provider, and a judge overseeing the program so that there was intensive supervision in the beginning with a lot of urinalysis exams, meetings with probation, and then stepping down so that the end of what at the minimum was a year program, sometimes longer than that, an individual would hopefully be fully employed or going to school. So it was a really great program. We did not have any specific dollars that were earmarked for that program. Every single member of that team just took out additional part of their time, their regular jobs, to be a part of that team to help increase public safety, help people manage addiction, and get to be back to being productive members of the community.
So what was the result?
The result, you know, I do not have the statistics in front of me, but my understanding is that recidivism was reduced. And amazingly, like I said, so many people ended up with full-time jobs at the end of the experience and really being able to contribute to the community. So it was an important public safety result and an important result for our community in terms of getting people back into work.
Thank you. Mr. Murphy and Ms. Vargas, as I look at your backgrounds, it's interesting, the contrast in a way, and I'm going to ask you to comment on it. Mr. Murphy seems to have dedicated a large part of his professional life to defense work, primarily at that table. Ms. Vargas, prosecuting has been part of your background. And the concern, obviously, from the members of the committee, as has been expressed over and over again, is can you see the other side of the story? Will you treat the prosecutor, in your case, Mr. Murphy, with the same level of respect and professional courtesy that you would want for yourself? Ms. Vargas, can you put yourself in the shoes of a defendant who's fighting for their rights and wondering if you as a judge are going to be fair in your verdict? I'd like to ask each of you to comment on that. Mr. Murphy first.
Thank you, Senator. Yes, I believe that I can switch from the role of an advocate to the role of a neutral arbitrator successfully. I think my experience working with people has given me a great deal of time trying cases. So I've tried many cases to a verdict in front of a jury, and understanding how the judge in each of those cases provides a forum that allows both advocates to present their case fairly and fully such that they feel like their side of the house has been heard completely by the time that case is decided by the finder of fact, be it either a judge or a jury, is something that I would seek to emulate, and I think I can make that transition from being an advocate to being a neutral arbitrator.
Ms. Vargas.
Thank you for the question, Senator. As primarily a civil AUSA who's also done civil rights, criminal prosecutions, I have litigated on both sides of the V frequently, both as plaintiff attorney and defense counsel. So that has been a large part of my experience and has given me a breadth of experience and a depth of understanding of what it means to be both a plaintiff's counsel, a prosecutor, as well as on the defense side. But more importantly, as AUSA as a government attorney, we are advocates, but we are also we take an oath to uphold the Constitution. We're government attorneys. We have that higher obligation to the rule of law. That's part of the reason that I've enjoyed my job so much was that aspect of it. And if I were so lucky to be confirmed, I would look forward to taking on a role where fidelity to the rule of law would be my paramount consideration.
Thank you. Senator Kennedy.
Thank you, Mr. Chairman, and congratulations to all three of you. Judge Pinnell, you are a political activist, aren't you?
Thank you, Senator Kennedy. I am a judge on the Washington State Court of Appeals. I don't consider that to be a political activist.
Okay. In 2020, you and 10 of your friends issued a written statement. You entitled it, quote, Statement on Racism, White Supremacy, and Justice. Here's what you said. I'm quoting from you now. Racism and white supremacy currently plague every social, educational, economic, governmental, and legal system. Racism and white supremacy currently plague every social, educational, economic, governmental, and legal system in our state and in our nation. And they have for centuries. Both, you're referring to your state and America, both target black, indigenous, African American, Latinx, and other people and communities of color, resulting in entrenched inequality and inequity, manifesting in unjust, unfair, and differential treatment, and yielding remarkably disparate and negative outcomes relative to those experienced by white people. End quote. Did I read that accurately?
Senator, I don't have it in front of me. I don't have any reason to think that you did not read that correctly.
Okay. You are very active in Planned Parenthood, are you not?
No, Senator.
Okay. Well, Planned Parenthood, in its annual reports, lists you as a, quote, silver friend, close quote. Do you know what a silver friend means?
I don't, Senator.
That's someone who has donated between $1,000 and $2,500 to Planned Parenthood of Greater Washington and North Idaho. That's in the Planned Parenthood annual reports. You don't know anything about that?
I don't recall. What I recall, Senator, is that my husband had donated to Planned Parenthood, and I think at some point in time they listed me along with him, but I believe that was a donation.
This is you.
Okay.
And in fact, they say that as of 2018, you've been a donor for at least 10 consecutive years. Is that right?
I do not recall donating them for the last 10 consecutive, 10 years before 2018 or 10?
That's as of.
I don't recall, Senator.
Okay, you don't remember. Okay, let me ask you, you're on the Court of Appeal. Let me ask you about a few of your cases. Do you remember a case called State v. Westwood?
I believe so, Senator.
And you were reversed in that case, weren't you?
Senator, in reviewing my cases, I think I've been reversed in about 2% of the cases that I've issued. I've issued almost...
Were you reversed in that case, though?
That was a very complicated case regarding sentencing law.
But I'm going to run out of time, and I got a bunch of these.
Okay.
Were you reversed?
That might have been one of the 2% of the cases. I think so.
reversed?
I believe that was one of the 2% of cases,
You remember
Senator.
a case called Personal Restraint of Heiress?
That, I think, was the case regarding whether or not the person had been deprived.
Were you reversed in that case?
That was, I think I was not reversed.
Were you reversed in that case, counsel?
Senator, I think that I wasn't reversed as to outcome, but it was one of the 2% of the cases where the state Supreme Court disagreed with the analysis.
You remember a case called Parental Rights of ALK? Were you reversed in that case?
Senator, I think that was one of the 2% of my over 450 cases where there was a reversal.
Do you remember a case called State v. Log Bomb?
I recall that case, Senator. That case.
Were you reversed in that case?
That was one of the 2% of cases. I issued an opinion to affirm a conviction, and the state Supreme Court overruled that and reversed.
Remember a case called State v. Barboza v. Cortez? Were you reversed in that case?
Senator, that case is not coming to mind. Again, I've issued over, myself personally written over 450 decisions.
You remember a case called State v. Telvik?
Senator, I think I recall that name. That might have been one of the 2% of cases.
In that too?
That might have been one of the 2% of cases,
okay.
Senator.
Another case, Hendrickson v. Moses Lake School. Were you reversed in that case?
Senator, I recall that case. I think that might have been one of the 2% of cases where the state Supreme Court disagreed with the analysis of another appellate court.
Were you reversed? You remember a case called State v. Curry? Were you reversed there?
Senator, I think you're reading off all the cases. I think that's one of the 2% of cases.
Okay. How about a case called State v. Rathbone? Were you reversed?
That's probably one of the 2%, Senator.
How about a case called Douglas v. Shamrock Paving Company?
Senator, that's a case where I was largely affirmed. The only thing that was a reversed, I included everything, even if it was just a partial reverse. The only thing that I was reversed on was an award of attorney fees. The substance of the law, which was rather new in that case regarding what constituted an investigation for an environmental cleanup.
You weren't reversed?
That part of it I was affirmed.
Yeah, I think that would be a surprise to the Supreme Court that you weren't reversed.
Okay, thank you, Senator.
I'm out of time. Thanks, Mr. Chairman, for your indulgence.
For the record, what is 2% of 450?
I think it's about 11 cases, if memory serves, 11 to 12 cases of the cases that I've written, many of which are grappling with really novel issues. And so that's what happens.
11 out of 450?
Over 450 that I've written myself.
Senators should be so lucky. Senator Booker?
I haven't been right 98% of the time today. Ms. Purnell, I am in awe of your career, frankly, and your commitment to the ideal of justice in this deepest sense of the word. You clearly have a body of work that demonstrates your expertise in the law, your balanced thinking, your thoughtfulness on complex issues, and you're willing to grapple with a lot of the novel issues that come to the courts these days. I have a little frustration right now, really with all three of the people before me, is that you talked about the family that was present, but I have no idea who's who. It's like a sea of humanity behind you. So Ms. Purnell, can you actually point out your family, if they'll raise their hands?
So my family is in what, the 4th row?
All right, the 4th row, fantastic, fantastic. Ms. Vargas?
So my family and friends span the 2nd and 3rd row here.
And you spoke to children, are they here?
My children are not here, they're back in New York today.
Okay, okay.
They have school.
They have school, okay. Mr. Murphy, your kids or family?
My family's in the first 2 rows, the 3 kids next to my wife, Lindsay.
Oh, so your children are scofflaws today.
I'm sorry, Senator, they were quite disappointed at school vacation week. They were hoping this was going to be next week.
That's fantastic. And that's your son there with that big afro?
That is.
I'm very jealous of him, I have to say. Ms. Purnell, you talked a lot about something that goes on in New Jersey a lot, where judges and prosecutors on their own time do reentry work. It's pretty stunning to me that how committed they are to that cause, and their success rates, as you say, these stories, it can't be understated how much of an impact it makes on their families and lowers recidivism rates. And I just wonder if there's any lesson as a judge that you've learned from that. Could you reduce it for yourself to maybe one sentence or two about what you've taken from that experience?
One of the things I took from that experience is fidelity to process. One of the things I first learned when I went into drug court, it is not about your own instincts on who's going to do well in drug court and who's not. You really need to follow a model. for this is the level of treatment that the individual needs, the type of interventions they need, and don't let maybe your affinity for this defendant get in the way. You need to follow the model. And that's been really helpful, I think, also for adjudicating cases. Follow the model, follow the rule of law, follow the precedent. Don't let your biases get in the way so that you can come out with the best outcome. And I think that that's really important for anyone working in a substance abuse treatment program or a drug court program.
Yeah, it's extraordinary. And we've done a lot of bipartisan work on reentry, but there's still gaps that people like yourself have been stepping up to make the justice system far more just. And we have a lot to learn from your experiences, and I appreciate that. Mr. Murphy, you know, one of my senators that I learn a lot from, maybe because she's professorial, is a good senator from Massachusetts. In this case, she told me what to do, which was to be nice to you. And so I am going to adhere to that direction. And please report back to her that I was nice.
I'm in your debt, Senator. Thank you.
Thank you. Why is the diversity on the bench, not of racial diversity, ethnic diversity, religious diversity, why is it important to have people like you who have had work which is not as diverse, I think, as it should be, but I'm wondering if you could speak to the diversity of having defense attorneys, public defenders. Why is that important?
So I think representing individuals in criminal prosecutions gives you an insight into how people find themselves in front of the court. And so you have a better understanding of the backgrounds that they've gone through and some of the struggles that they've gone through. And so you can see the humanity of the person in front of you. And you can use your ability to see the humanity of the person in front of you to really fashion the way the court interacts with them, the types of sanctions that are imposed in a way that's productive and helps sort of get them back on the right track.
Thank you very much. I appreciate you, Ms. Purnell. You're bringing this incredible diversity. Ms. Vargas, you and I were both at Yale Law School during the 1990s. My professors would always look at me and say, these are some of the toughest years that I've ever had to teach at Yale Law School when I would be in their classes. Did you have that experience with your professors? Did they talk about them as being really tough years for them?
I have to say that no. I had wonderful professors while I was at Yale and made incredible friends that have lasted me a lifetime and helped me throughout my career. But it was a wonderful place to go to school with a place where academic debate flourished, and I really much enjoyed my 3 years there.
Yeah, I had a tough experience of having one of my professors, Akil Amar, come to be on a panel here, taking the position opposite to my own. It's very intimidating to me because I don't know if he can still revoke my degree, but because he did let me pass his class.
Well, Professor Amar was also my my criminal procedure professor and my constitutional law professor, so I have had that similar experience.
Did you have Owen Fiss at all?
I did as well. I worked with him on the Linkahe program as well, which he ran at the time.
Right. And well, I miss his thick accent, but I'm grateful that you're here. I've just been gavelled out by one of the men.
Save it for the alumni meeting.
By one of the people I respect the most. I will just say in conclusion, all three of you give me great hope. I'm excited that you're here. I'm grateful for your willingness to serve. I'm excited by your families, and I wish you the best in your careers. Thank you.
Thank you to the nominee.